All right, today we're going to look at the living Constitution, and we're going to discuss what it means for a Constitution to be alive. Let's start with this quote: "The dead should not rule the living," or as a truer one would be, "The Constitution was for the living and not the dead." A quote by Thomas Jefferson. What they meant by this was that the Constitution should always be changing, okay? Uh, the Constitution is not a static document. It has to change to meet our needs. And that is kind of the root of the idea of a living Constitution. Uh, when the Founding Fathers talked about the right to bear arms, people had muskets. They weren't thinking in terms of tanks and machine guns. However, they were thinking in terms of the people should have the same weapons as the state should. Okay, so you have to consider this kind of stuff when you're looking at the Constitution. So, how is it that we have a Constitution that survived for over 200 years and only has 27 amendments? Why is our Constitution so good? Let's look at the ways of keeping the Constitution up to date without frequent amendments. The first big way is through congressional action. Congress can modify the Constitution through passing laws and not actually have to modify the original document itself. We can pass laws on how the Constitution enforces laws. A great example is the Judiciary Act of 1789. This created the federal judiciary. If you don't know what a judiciary is, it's the court system. All the Constitution says is that there will be a Supreme Court and as many lower courts as deemed necessary. The Judiciary Act of 1789 established the national court system. Another example is presidential succession. What happens if the president dies? There was some question about this. We have a president and a vice president, but there was question as to whether or not the vice president becomes the president upon the death, or if they just take on the authority of the president. And beyond that, what happens if the vice president dies? Well, today we have a system. We created the Presidential Succession Act. If the president dies, leaving that office vacant, the vice president becomes the president. In the event that both the president and the vice president are unable to fill that position, it goes to the Speaker of the House and then to the cabinet officers in the order that they were created. The second way of keeping the Constitution up to date without frequent amendment is through judicial interpretation. The court can interpret what laws mean. This was established in 1803 with the Supreme Court case Marbury versus Madison. Super important case. You must know this case. Marbury v. Madison established the doctrine of judicial review. It established the precedent that the court can determine whether or not an act of Congress is or is not constitutional. And when they did this in 1803, determining whether or not Marbury was going to get his position as a judge, a position that he'd been appointed to by John Adams before he'd lost his reelection bid. And Secretary of State James Madison had refused to grant him this job. Whenever this was determined by the court, it didn't matter what they determined. It just showed the court had the authority. So today, the court has the ability to rule an act of Congress unconstitutional simply because it took it in 1803. Another important case about this is Plessy v. Ferguson, one of the most important cases in all of American history, judicial history. Homer Plessy was 1/8 African American, and he sued for the right to ride in a white railroad car. But under the laws of the time period, one drop of African American blood meant you were black. So in 1896, Homer Plessy was forced to ride in the black railroad car. He sued under the grounds that he was a citizen of the United States and should have all the rights of citizenship. The court ruled the separate but equal doctrine. Super important. The doctrine of separate but equal says that segregation is not discrimination so long as the facilities separate are equal, separate but equal. Of course, the great truth was they weren't ever equal. But that was 1896, and that's going to remain the law of the land until 1954. So for 58 years, Plessy v. Ferguson is going to be the rule of the land until it was overturned in 1954 by the Brown versus Board of Education case, where the court ruled that segregation was in fact discrimination and therefore illegal. It repealed the Plessy decision 9-0. This is a great quote. It's from Chief Justice Hughes, who said, "The Constitution is what the Supreme Court says it is." What he meant by this was that the Constitution can be interpreted by the court to have different meanings at different times. That's why the same court in 1896 could say segregation is okay, and then in 1954 reinterpret that law and say, no, it's not. President Wilson said, "The Supreme Court is a constitutional convention in continuous session." I love that quote. And what he means by this is just by the way the court rules on cases, they're continuously rewriting the meaning, if not the words, of the Constitution. The third way of keeping the Constitution up to date without frequent amendments is through presidential practices. Sometimes the president can just take an authority. George Washington established the precedent of having a president's cabinet. Washington needed advice, and he knew he couldn't go to the Congress or to the court because of the doctrine of separation of power. So what did he do? Well, he called his executive department secretaries. At that time, you had Secretary of State Thomas Jefferson, Secretary of Treasury Alexander Hamilton, and Secretary of War Henry Knox together for advice, and he called those his cabinet. They were informal advisors. They had no force of law, but he established that precedent. And every president since Washington has used his cabinet for advice. They haven't always listened to him. Abraham Lincoln famously ignored his cabinet, who believed that the Civil War should not be fought. Lincoln took us into that war anyway because he believed it was the right thing. So the cabinet has no force of law, but every president has used it. John Tyler, that's the guy in the middle there, was the first president or vice president to take on the office of president upon the death of his predecessor. John Tyler simply goes and gets himself sworn in as president and just takes that authority. Remember, the Constitution just says the vice president takes on the authority of the president. But since John Tyler had himself sworn in and nobody argued with him, ever since then, the precedent has been set that a president is sworn in from the vice presidency upon the death of a president. And there on the far right is Dr. Thomas Woodrow Wilson. Wilson was president during World War I, and he was the first president to leave the continental United States while serving as president. And he took the authority of the president with him and negotiated the Treaty of Versailles ending World War I. There were people that actually believed that when the president left, his authority stayed behind with the vice president. Wilson disagreed and established that precedent. 4 is customs and usages. Sometimes we just start doing something and it becomes part of the system, like political parties. We all know there's 2 major parties, the Republicans and the Democrats. But constitutionally, there's no parties in the Constitution. There's no requirement that a president be a member. But because our 2 founding fathers, Thomas Jefferson and Alexander Hamilton, founded the Democratic Republicans and the Federalists, or Federalists and Anti-Federalists, if you will, they established the 2-party system that we still have today. Some would argue, myself included, unfortunately. And in 1831, we established the precedent of nominating our president through a nominating convention. And all the major parties have used nominating conventions since then. We will pick up with the 7 principles of the Constitution next time. Thank you, guys.